Good day. My name is Mark Mellor. I'm an attorney here in Riverside, California. I have a number of contractor and homeowner clients, and property owner clients in Barstow, California, deal with mechanics lien issues. So I thought I'd make a quick video to go over some of the rights and responsibilities and some of the things you need to pay attention to when dealing with mechanics liens on your property or trying to recover payment on property you've worked on. If you're a contractor, you want to make sure that you are in direct contractual privity with the owner. If you are, you don't have to serve by certified mail return receipt requested a 20-day preliminary notice. If you're not in direct contract with the owner and you happen to be a sub of a sub or a subcontractor to a general contractor, then you want to make sure you serve by certified mail return receipt the 20-day preliminary notice under California law. Now, what does that look like? That's a form that basically says who you are, what you're doing, and how much the scope of your contract price is, and you give notice to the lender, if any, on the project, the owner of the project, and obviously the general contractor on the project, so they all know that you're there. You want to do that within 20 days of mobilizing on the project, whether that's delivering materials or starting your first work. You want to make sure that you do that so it covers those payments for you if you have to then record a mechanics lien later on. Now let's talk about that. If you're not in direct contractual privity with the owner, then to record the mechanics lien and have a valid mechanics lien right, you have to have sent your 20-day preliminary notice out. Assuming you've done that, now you can record the mechanics lien. When do you have to record that by? You have to record the mechanics lien within 90 days of you leaving the project, meaning your last work on the project. If you come back and do touch-up work or button-up work, you can count that last day as your last day. But whatever the last day is, you've got to record your mechanics lien within 90 days of that date. Once you do record, the next step to remember is that you've got to file a lawsuit to enforce your mechanics lien rights within 90 days of recording that mechanics lien. If you don't, the mechanics lien rights that you tried to obtain by recording that mechanics lien against the property go away, and in a summary motion filed by an attorney, we've done them before, you can have that mechanics lien expunged from the record with the attorney's cost for doing so going against you if you refuse to release it. So you want to make sure that you file your 20-day preliminary notice, record your mechanics lien within 90 days of your last work on the project, and then you file a lawsuit, see an attorney to do that, within 90 days of the recording of a mechanics lien. Assuming you follow those steps, you can enforce your mechanics lien rights against the property and probably ensure that you're going to get paid on the project. If you're a homeowner or a property owner dealing with a contractor who has recorded a mechanics lien against you, you want to take a look at those very same steps. Was I in direct contract with the contractor at issue? Did they file a 20-day preliminary notice? Did they record their mechanics lien within 90 days of them leaving the project? Did they file a lawsuit within 90 days of leaving the project? You really don't have to worry unless all those steps were filed, because you can get the mechanics lien expunged from the property record if they haven't done those things. Regardless of your situation, whatever it might be, if you have any questions or you want to go over your particular situation, feel free to give me a call and I'll be happy to discuss your situation with you. Thank you.